Hello, everybody. I'm attorney Carol Nunez here with Coast to Coast Legal Aid. I'm here to present this month on National Child-Centered Divorce Month. Today, we're going to go over some time-sharing factors and some court interventions that are available to you. Next. So just a couple of disclaimers. Basically, this presentation is not intended to provide any specific legal advice. Everyone's situations and everyone's family dynamic is different. So make sure that you get correct specified legal advice if you need it. The information is current as of this year. Let's move on to the topic. So basically, July is National Child-Centered Divorce Month. It was founded in 2008 by Rosalind Sadaka. She is a divorce and co-parenting coach. She founded the Child-Centered Divorce Network after undergoing her own divorce. She is a big advocate about how divorce affects the mental health of our children. Okay, so we're going to cover at what the purpose is of this month, what is considered a child-centered divorce and how it works, and how does Florida law promote this type of divorce in Florida, and some interventions that the court facilitates during this type of divorce case, or any divorce case really regarding children. Next. So the purpose of this month is basically to educate parents worldwide that our choices as parents have impact on children's mental and physical health, okay? We want during this month to raise awareness about the best ways that parents can handle divorce to protect your children's mental health going through the divorce process. We also want to teach parents how to communicate with their children about separation and divorce. Divorces are super emotional. So I've always been told that it's about 85% emotional and about 15% legal. So we want to educate ourselves as parents to be able to effectively make good choices while you're going through a divorce. Next. So what is considered a child-centered divorce? Okay, a child-centered divorce is a divorce that's going to focus on both parents making the decisions that are in the best interest of the children. And I know that this is a hard thing, okay? But this type of divorce wants to focus that everything is done in the best interest of the children before you even make the choice to be going through a divorce, during the procedure itself, and then also afterwards. The goal of a child-centered divorce is to reduce the psychological effects that the divorce has on the children. Next. So how do we achieve this in court? Okay, the first thing is that you want to try to stay out of court as much as possible. Even though the court system is there as a protection, as a guidance, and is very effective in helping a highly volatile divorce case. It doesn't lend itself to what's called a comparative, a mediated way to go through the court system. So you want to prioritize healing and recovering for yourself and your children, and focus on those factors of the separation versus revenge over the spouse and over the conflicts that arise during the separation. Okay. The focus is to create a stable, secure environment for your children. Consistency is key. So if you focus on those things and make your divorce and separation all about your child, it will be more effective to get to an amicable solution and reduce the effects on your children. You do want to not limit communication about your children. You want to open that communication with the other parent. You want to try to co-parent as effectively as possible during your separation. Next. So how does Florida law protect you or help in this endeavor? So basically the statutes in 2 sections talk about how the court is going to determine all matters relating to parenting and time sharing in the best interest of the children, okay? In two different sections, even when going through an initial proceeding or going and establishing or modifying what's called parental responsibility, and creating a parenting plan that's in your children's best interest. That is always the primary consideration, all right? So what do I mean by parental responsibility and time sharing? Okay, let's just go over what that means. Parental responsibility refers to decision making over your children. The typical custody situation, as it was seen in the past, led the courts to change the terminology because it was causing more contention in the court system. Families are all about cooperation. So they want parents to effectively co-parent because that will also limit how psychologically your children will be affected in the future. Okay, so let's talk a little bit more about best interest. So there are several factors. There's over 20 factors that the court can use and facilitate what's in the best interest of the children. The first one is the demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship, honor time-sharing schedule, and are reasonable changes. When going through a separation and you're sharing the children, it's sometimes hard. You have all these feelings of the separation conflicting with your choices as a parent. But the court wants to see that parents are encouraging and separating your personal relationship from your spouse versus their relationship with the children. So they look to parents who are going to facilitate and encourage that parent-child relationship remains intact. They're also going to look at the division of those parental responsibilities and how those responsibilities may be delegated to third parties. And I often tell my clients, everyone's entitled to a support system, okay? We all know that sometimes it's hard to parent yourself. That's why there's, a mother and a father in a situation. There's two parents, and it's usually a team effort. However, if one parent is delegating all their responsibilities to a third person and they're not taking accountability for their own actions, that's going to influence the best interest of the children. So you want to make sure that there is an equal division of those parental responsibilities. The next factor is the demonstrated capacity and disposition of each parent to determine, consider, and act upon the needs of the child as opposed to the needs or desires of the parent. Okay, and this is one of the hardest things, I think, for parents to quantify, because a separation is already a hard process. You're healing from your own process. If you don't attack that healing first, you will allow those emotions to infiltrate your parenting. So it is important that you consider what's in the best interest of the child versus what you want for the child. And those necessarily aren't always the same thing. The court's also going to consider the length of time the child has been in a stable, satisfactory environment and the desirability of maintaining that continuity. This is a factor that now with the new studies saying that children can have two homes, that equal time sharing with parents sometimes is one of the factors that the court considers probably last, because a separation does inherently have changes, and those changes are going to affect some of those things that are brought up in that factor. But as much as you can, if they have the same school district, if they stay in the same school, if they're in the same neighborhood or nearby neighborhoods, you want to try to make decisions that will affect the children in that way. Okay. The next factor the court considers is the geographic viability of the plan. How far are you guys under the separation? How far are you guys? Are the children going to be subjected to extreme amount of travel? Are the children going to be able to effectuate an equal time sharing schedule based on where the other parent is relocating, or whether both of you are relocating? Where is it going to be best viable for you guys to consistently do this equal time sharing plan? Next. The court is also going to consider the moral fitness of the parents, the mental and physical health of the parents, the homeschool community record of the child. That one is, it kind of goes hand in hand with that consistency. Same school district if possible. If the children are younger, then this is not such a relevant factor because they're not in school yet. If the children are older, it definitely affects. They want to see that the child is being consistent, that you're supporting your child for success, going through this. They're also going to look at the reasonable preference of the child. Again, this is more age-related preference. So if the child is a teenager, they're definitely going to have the capacity to make certain choices. But the court's also going to look at what is being offered. Children can be persuaded one way or another. Okay. They're also going to look at the demonstrated knowledge, capacity, and disposition of each party to be informed of the circumstances around the child, including but not limited to child's friends, teachers, Medicare providers, daily activities, favorite things. You want to make sure that both of the parents are aware of this and that they show that they have a capacity to be informed on what's going on around the child, because you want to set them up for success. The next factor is basically consistent routine. Okay. So which parent has the consistent routine, such as discipline, daily schedule for homework, meals, and bedtimes? Sometimes this is where the conflict sometimes arises because, different schedules, different work schedules, so those are all considerations you want to sit with your potential spouse in a potential separation. Next. You also want to look towards the capacity of each parent to communicate and keep the other parent informed. So it's important to sit down and review these factors with your spouse if it's amicable, and focus on all of these factors. Go over it with them and show that the court is going to want to see these things, right? So you want to communicate with and keep the other parent informed of these issues. Obviously, if domestic violence is an issue, a perfect child-centered divorce might not be the best way to go about it. You might not be able to do it amicably, but there are interventions in the court that you can use to force the other party to become educated on these issues. Evidence that a parent has knowingly provided false information, again, goes if there's health and safety reasons, then you do want to make sure the focus is on protecting that health and safety of your child. The court also is going to look at the particular parenting tasks that are customarily performed by each parent. The division of those responsibilities before the fighting started, and then to the extent that during litigation they're still going on, and what responsibilities have been taken by third parties due to the conflict. Next. So they also want to see to what extent parents are disposed to participate and be involved in child school, extracurricular activities. Again, this is more an age-related issue, as it depends on the age of the children and how much school extracurricular activities are actually available to the parties. They also want to look at the capacity and disposition of each parent to maintain an environment for the child which is free from substance abuse. So they're going to look at, those situations, whether, substance, alcohol, drugs are available to the children in these other environment. Again, this goes to, primarily focusing on safety and health of the children. They're also going to look at the capacity and disposition of each parent to protect the child from ongoing litigation. So if there is fighting, if you're in court, if you gotten to that point, to what extent are you guys keeping the separation and the court process from the children's ears? refraining from disparaging comments in front of the parent, not allowing the emotional side to impact your children's mental health. They're also going to look at the developmental stages and needs of the child. What age is the child? What is age appropriate for that child? The demonstrated capacity and disposition of each parent to meet the child's developmental needs. Okay. And then the last factor is basically where discretion of the court is involved. Any other factor that is relevant to the determination of a specific parenting plan, including the time sharing schedule. So the court is willing to take in any other factor, like whether dad's work schedule is accommodating to a 50-50, whether dad has the proper accommodations. These are things that are not specifically listed, but that are definitely relevant in the determination of a time sharing and a parenting schedule. Next. Okay. So what are certain interventions that the court can offer to help you through this process if you've gotten to that point? There is a parent coordination. There's actually a person that can be designated by the court to focus on just the children's issue and how to help with the fighting, with the conflict. Okay. It does require a court order. Okay. And it emphasizes improving parents' decision making and educating the parent on how to effectively co-parent. Okay. This is in situations when one parent is being cooperative and the other one is being very non-compliant. They see lack of following court orders. They see that there is constant decision-making against the best interest of the children. And so the court may order a parent coordinator to come in and help. This parent coordinator's purpose is to help improve that co-parenting relationship. Okay. They make recommendations to the court based off of what they think would work in a parenting plan for your specific case. Okay. They create, modify, and help implement that parenting plan that we've discussed. Next. There is also other resources for co-parenting. There's a type of therapy that works with parents to improve shared caretaking of the child. Court can order co-parenting classes, workshops. In the process of your divorce or paternity case, the court does mandate that you take a co-parenting course. It's an online or in-person course that you take. It gives you lots of skills for co-parenting and helps. But in cases where maybe there is documented evidence that this person just does not know how to co-parent, has not been around the child sufficiently to know basic needs, you may ask the court for more workshops or classes towards that effect. I've also had cases where a co-parenting class is awarded because of a special needs child. Like the special needs has requirements that are not typical of every other parent. And so the court can order additional training or, classes for that. And this type of situation is good for parents who just want guidance, education, and help with co-parenting, but are not necessarily hostile, just don't know how to approach it. Part of it is therapy that is kind of solution focused versus conflict focused. It can be done by mutual agreement. You guys can agree we both will take these classes to help us in the future, or it could be by court order. Okay. Next. Okay. So in cases where there's been alienation of parenting, or a person has been just lacking, abandoned the child, there is a process by which you can reunify that child with the parent. So it helps the child resolve parent-child conflict. So there are cases where the child is so angry that they take it out on one parent versus the other, so they will refuse to see the parent. They refuse to do the time sharing. The court may look at reunification to repair that parent-child relationship, whether it's due to parental alienation from one parent, or whether it's due just because Children are very intuitive, and they sense things, and so they will sometimes take it out on one parent versus the other. Okay. So this type of reunification is mainly involving when the child is the one that's refusing to see the parent. It does not require a court order, but it is recommended, especially if one of the parents is refusing, or just um, saying the child doesn't want to see you, so I'm just going to continue withholding the child, even though, I have a court order that says you need to see the child. So you might want to ask for a court order for a plan for reunification with the child. Okay. And this is going to be going back to, those therapists. They're going to work with you. And it works to get both parents back to a consistent parenting plan. Next. Another type of intervention that the court can help out with is family therapy. And family therapy can be ordered for all members involved in the divorce case. It is helpful, I think, for all cases to benefit from family therapy because, like I said at the beginning, divorce cases are 85% emotional and maybe 15% legal. Therapy can be beneficial for all parties. It teaches parents how to co-parent effectively. It helps each of them heal individually, and it helps the children through the process, so their mental health isn't negatively affected through the process. And so it does involve the parents, the children, new partners if applicable, and anyone else that's considered within the family unit. So, some parties live with grandparents, some parties live with, siblings not of the marriage. Family therapy would include everybody who's involved. It can also involve individual therapy. So, there's family therapy where all of you are present, and then there's individual therapy or therapeutic time sharing. If there's, problems with reunification, that's usually helpful in trying to repair that parent-child relationship. And again, this is another type of intervention that is, it can be by mutual agreement. It can be, we're having difficulties, we're recognizing that we need the help. Let's do it by mutual agreement, or it can be done by court order. Okay. And it also follows the parenting plan. Next. Okay.